This is part 6 as far as our series of lecture series is concerned on the Indian Penal Code of 1860. During the first few parts, we tried to understand as to what we are going to learn or what we should learn by reading the provisions of the Indian Penal Code. And during course of time or by this time, you must have understood that it is necessary for us to know the offense. And what do you mean by an offense? The word offense denotes the thing made punishable by this code. So the thing that is made punishable by the provisions of this code, namely the Indian Penal Code, is what is known as an offense. But as we go on learning, many offences which are defined by various sections of the Indian Penal Code you will come to know. In order to understand an act which amounts to an offence, it is must for you to know the maxim, namely actus non facit reum nisi mensit rea. And what is the meaning of this maxim? The meaning of this maxim is that the act and the intent both must concur to constitute an offence. In other words, if you want to simplify the meaning of the maxim in the form of an equation, as a result of which it will be possible for you to remember it forever, it's very simple. Offence is equal to mens rea plus actus reus. Now what do you mean by mens rea? By mens rea we mean guilty mind. And how you come to know this mens rea or the guilty mind? By reading the section. Once you try to find out as to what should be the state of the mind with which a particular act is required to be done, that is exactly the state of the mind which is described as what is known as mens rea by various, not by this term mens rea, but by various terms with which we shall be dealing when we come across, we shall be dealing with the different sections of the Indian Penal Code. And then what do you mean by actus reus? It says it means such a result of the human conduct that law seeks to prevent. And hence, let us start with very simple illustration. Somebody is under impression who is in the classroom and he takes away a book. At the time of taking away a book, he is under impression that he is taking his own book. But then it is noticed that he is not taking his book, but he has taken, because of the mistake of fact, he has taken book of somebody else. Can it be said that he has committed the offence of theft defined by section 378 of the Indian Penal Code? Now, once we will start dealing with this section, namely section 378 of the Indian Penal Code, we will understand that unless intention is dishonest at the time of moving the property, the question of liability for the offence of theft as defined by section 378 of the Indian Penal Code doesn't arise. And what must be the intention? Your intention must be to cause either wrongful gain or wrongful loss. Now, what is wrongful gain? Gain by unlawful means of the property to which person gaining is not legally entitled. Now, was that his state of the mind? Whether he wanted to cause wrongful gain to himself? And the answer is in the negative. So, though he has taken away property out of the possession of some other person without the consent of that person, as the intention was not dishonest at the time of moving the property, he is not liable for the offence of theft as defined by section 378 of the Indian Penal Code. So, dishonestly is mens rea to constitute liability for the offence of theft. Now, we are not here working out details regarding this concept and the maxim you will appreciate and you will understand and you will come to know only when you know the offences in detail with which we shall be dealing. But as we are dealing with offence, you must know it's not only act that is made punishable, it's not only intention that is made punishable. Act done with a particular intention is only made punishable by the provisions of the Indian Penal Code. Now, you modify the facts of the case and there imagine a situation where the person wanted to take book of somebody else. Whatever may be the reason, he wanted to take book of somebody else. He picked up the book from the classroom and when he went home, it was noticed by him that he had not taken book of somebody else, but he had taken his own book. What is his liability? Now here he had mens rea, yes, but then mind well he wanted to take away book of somebody else, but here in the absence of actus reus, such result of the human conduct that law seeks to prevent, as this act of taking your own book is not at all made punishable, and hence what we say here, there is a mens rea, but there is absence of actus reus, in the absence of which what we cannot say that he is liable for the offence of theft as far as section 378 of the Indian Penal Code is concerned. So similarly now, during course of time, this is as far as theft is concerned, though dishonestly explains the state of the mind of an individual. Now the person wanted to take a book, and the person wanted to deprive somebody of the book, and hence what he had done, such a person went to the person, told him that he wants a book for 2 days which he will return. He took the book and never returned the book. What is his liability? Now during course of time, when we will learn section 415 of the Indian Penal Code, which defines the offence of cheating, here you will come to know the state of the mind of an individual. The act was done fraudulently. And why we say it was done fraudulently? Because when we will deal with section 415, there you will come to know section 25 defines fraudulently, and it says a person is said to do a thing fraudulently if he does that thing with the intent to defraud, but not otherwise. And what do we mean by defraud? By defraud we mean somebody practices deception. There are two ingredients: one, practicing deception, and deception resulting into causing of an injury. And what is the meaning of the term injury? As defined by section 44 of the Indian Penal Code. So this he would not have parted with the book if this fact would have been known to him that he is not going to return the book. So he made him to believe that he is going to return the book. Actually, in fact, he never wanted, and hence took away the book. Now during course of time, we will try to understand meaning of the term consent also, because consent plays very important role as far as liability of an individual is concerned. If you do an act with the consent, you are not liable. If you do an act without consent, you are liable as per the provisions of the Indian Penal Code, with which we shall be dealing. So here in this problem, what was the state of, he has done that act fraudulently because he has practiced deception, which has resulted into causing of an injury. Now when we will deal with one more term, namely what do you mean by voluntarily, there you will come to know voluntarily is the state of the mind. And what do you mean by voluntarily? If you analyze section 39, and we will come to this at the time of discussing in detail the offence of voluntarily causing hurt and the offence of wrongful restraint, where the state act must be done voluntarily on the part of an individual. What is this voluntarily? And then you will come to know if the act is done with a particular intention, it can be said that it is done voluntarily. Even if it is not done with a particular intention, but if the person, for example, has done the act when he knows the consequences of the act because of the means that are employed by him, or he has got reason to believe, then naturally what we say, so there are two aspects. When the act is done with the intention, it can be said that it is done voluntarily, and when the act is done with the knowledge, then also it can be said that it is done voluntarily as far as section 39 is concerned, which also explains the state of the mind of an individual. Now if you read section 299, which defines the offence of culpable homicide, it says whoever causes death by doing an act with the intention of causing death. So when there is an intention to cause death, this is the intention is the state of the mind, or with the intention of causing such bodily injury as is likely to cause death, that is also the state of the, or with the knowledge that he is likely by such act to cause death, commit the offence of culpable homicide. During course of time, when we will deal with section 304A, rashness is also the state of the mind of an individual. Negligence also forms state of the mind of an individual. So this is with which we shall be dealing. And what we have learned so far? We have learned so far that mere act is not made punishable by the provisions of the Indian Penal Code unless it is done with a particular criminal intention. And this criminal intention, namely mens rea, is defined as far as Indian Penal Code is concerned when you read a section which defines an act which amounts to an offence. And how, how the actus reus has been defined, when you find out is say ingredients to constitute an offence, and then if you take out from those ingredients, if you take out state of the mind of an individual, whatever ingredients remain, those ingredients constitute what do you mean by actus reus, namely such a result of the human conduct that law seeks to prevent. So this is, I mean, first part. As I told you, we have not done with it mind well. We shall be dealing again with it, but then right in the beginning you must know that mere act is not made punishable by the provisions of the Indian Penal Code unless it is done with a particular criminal intention. With this now, when we talk about the substantive law, namely the Indian Penal Code, mind well, we always take into consideration duty of a person. It's, I mean, he is bound by law, and then, I mean, because it is a substantive law, and for example, Mr. A, it is his duty not to kill Mr. B, and if he kills Mr. B, we say that he has failed in his duty, and there starts his liability. But then when we talk about duty, mind well one thing forever, it is a legal duty. And when we say legal duty is required to be defined somewhere, and that is defined as far as the provisions of the Indian Penal Code are concerned. At times there may be a situation where the person has failed in his moral duty. If a person fails in his moral duty, the question of liability doesn't arise. And hence, this, I mean, this aspect with which we will continue our discussion during course of time. But then the distinction between moral duty and legal duty. Moral duty is that where it is required to be done, but it is not defined anywhere as far as the law is concerned. And then with this aspect now, as a student learning Indian Penal Code, at times it is necessary for you to know the distinction between, you come across two terms, intention and motive. Now mind well, intention, there is a clear-cut distinction between intention and motive. Intention is the state of the mind of an individual with which a particular act is done. And what is motive? Motive is what is meant by ulterior intention. So motive, you, I mean, take some eatables without permission of the say manager of the hotel in order to save somebody who was dying because of starvation. You give him. Now there you have done good thing, you have saved a life, but what you have done, this is motive will be praised by everybody, no doubt about it. But even though the motive will be praised by everybody, there it is what was your state of the mind. You have taken the property out of the possession without the consent of the person, and that is wrongful gain to you. Hence your liability is for the offence of theft as defined by section 378 of the Indian Penal Code. When you want to get yourself elected unopposed and hence you kill somebody, mind well, your motive is to get yourself elected unopposed, but you have killed him, and hence this is the state of the mind. What we take into consideration as a student of law, we always take into consideration the state of the mind of an individual with which a particular act is done, and the purpose for which it is done. Ulterior intention is what is motive, that is never taken into consideration as far as it may be laudable, everybody may be praising for the same, but then also you are liable because motive only becomes relevant. In all cases it is irrelevant. What was your motive will never be taken into consideration. But when you deal with section 8 of the Indian Evidence Act during course of time, motive becomes relevant from the point of view of inferring the intention, namely what was the state of the mind of an individual at the time of doing a particular act. So this is regarding intention and motive, with which I mean we during course of time. This is just I am trying to introduce few terms to you, so that if you are familiar with those terms, it will be very easy for you to understand the chapters with which we shall be dealing. This is one aspect. With this now, whenever somebody, now we come to the next aspect, and what is that? Whenever somebody wants to commit an act which amounts to an offense, it's not that you think that the offense has taken place. No, 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 certainly not. And hence, it is necessary that the person should undergo various stages. What is the first stage? The first stage, as far as commission of an offense is concerned, is intention to commit an offense. This is the first stage. You have in the mind that you want to, for example, a person from this place wants to kill somebody who is at some other place. Yes, his intention is to commit the offense of murder. That is one thing. Two, now after intention, he will have to undergo a stage of what is known as preparation. What is the manner in which he is going to kill? Which is the weapon that he is going to, what weapon or what are the means that he is going to employ? As you know that a human being can be killed by n number of ways, what he is going to adopt. So he will plan accordingly. This is what is known as preparation. After preparation, the person will do a direct act, and then if the direct act, the result of the direct act is achieving the goal or the object. So he, A, wanted to kill Mr. B. If he kills Mr. B, then we say he is liable for the offense of murder. But there are cases when whatever is required to be done on the part of Mr. A, if it is done by him, and if he is unsuccessful as far as achieving of his goal or object is concerned, in that case what we say, he has gone beyond the stage of the preparation, there is attempt on his part, and in case where the attempt is unsuccessful, we say person is liable for attempt to commit an offense which is also made punishable by the provisions of the Indian Penal Code. So these are various stages. A, intention to commit an offense, and mind well now, intention to commit an offense is not at all made punishable by the provisions of the Indian Penal Code. For example, A started from his place. Unfortunately, it so happened that as he was in the door, he was arrested in the door by the police officer on the accusation that, well, your intention is to commit an offense. What is his liability? And there we say, mere intention, as long as it rests in the mind of an individual, as there is every chance or possibility for him to change his mind, and it is not possible for anybody to prove in a court of law as to what was in the mind of an individual at a particular time, particular point of time, and hence mere intention, when it rests in the mind of an individual, that is not made punishable by the provisions of the Indian Penal Code. Now what he will do when he wanted to kill Mr. B, he may decide to kill with the help of the revolver, and for that purpose he may go to the market, purchase a revolver. He may get down at the place where Mr. B is residing, and if he is arrested by police at that time, what is his liability? He is not liable because this is a stage of preparation. And why we say this is a stage of preparation? Yet he has not done any direct act towards commission of an offense, and hence this is just what is known as preparation. In case of preparation, there is every chance or possibility for an individual to withdraw, and hence mere preparation to commit an offense is also not made punishable by the provisions of the Indian Penal Code, barring few exceptions. The one exception with which we shall be or you can refer to is section 122 of the Indian Penal Code. Read section 126 of the Indian Penal Code. These are the sections you will come to know when you start reading right from section 121 up to section 130, dealing with offences against the state. Whereas when we will deal with section 399 of the Indian Penal Code, where making preparation to commit dacoity is also made punishable. But otherwise, there is no offense, there is no, a preparation to commit an offense is not an offense and hence not made punishable by the provisions of the Indian Penal Code. As long as you are going this stage, namely preparation, the question of liability of an individual doesn't arise, and hence this you have to remember. Mere intention to commit an offense is not made punishable by the provisions of the Indian Penal Code. Mere preparation, barring few exceptions, in general, preparation to commit an offense is also not made punishable by the provisions of the Indian Penal Code. That is second aspect of which you have to take note. And now, once Mr. A, who wanted to kill Mr. B, goes to the place of Mr. B. He knocks the door, and as soon as the door is opened by Mr. B, he points out revolver into direction of Mr. B. And as he was about to pull the trigger, Mr. B slips on the ground, and the bullet went out of window. What is liability of Mr. A? 2. Mr. A wanted to fire into direction of Mr. B, but B's wife came from backside and changed the direction of the hand, so that bullet, instead of proceeding into direction of Mr. B, proceeds into direction of the ceiling. What is his liability? The third situation may be when A purchased revolver, the revolver was in working condition, no doubt about it. But when he went to the place of Mr. B and when he wanted to pull the trigger, he could not pull the trigger because the trigger went out of order. What is liability of Mr. A is the question for our consideration. Then the situation may be where A fires into direction of Mr. B. Mr. B hits him, and Mr. B is immediately taken to the hospital where he is cured because the bullet is taken out of his body and he gets a medical treatment in time. What is liability of Mr. A? And lastly, A wanted to kill Mr. B. He fires into direction of Mr. B, which results into death of Mr. B. He is successful. Now, the point of time where the liability starts. Liability for the offense is when he has accomplished the goal or the object. When he is successful, what he wanted to do, he wanted to commit murder, and he has killed Mr. B, so that is the end of it. But in a case where he has crossed the stage of preparation and entered the stage of what is known as an attempt, and if he is unsuccessful, then what we say, he is liable. Once a person crosses the stage of preparation and enters the stage of what is known as an attempt, if he is not successful, attempt to commit an offense is also an offense and hence made punishable by the provisions of the Indian Penal Code. Now, hence this is a time where it is must for you to know the distinction between preparation and attempt. And this can be understood, preparation, by taking into consideration some more illustrations. Now, what is the distinction between preparation and attempt? 1. As you read any commentary, you will, when you want to know the distinction between preparation and attempt, you will come to know, well, attempt begins where the preparation ends. There is thin and fine line of demarcation between preparation and attempt. But then, where it can be said that there is an attempt, when direct act towards commission of an offense is done on the part of an individual. Now, the person has reached such a stage that even if he wants to withdraw, he may be sorry for the consequences that are likely to take place, but there is no chance or possibility for him to withdraw. And what happens? He is unsuccessful because of the circumstances which are beyond his control. This is exactly the stage when we say person has crossed the stage of preparation and enters the stage of what is known as an attempt. And then when he is liable for attempt, now how to determine the punishment? Because if you have started doing homework, if you have been go on, as I told you, you read a section which defines an act which amounts to an offense, and the subsequent sections you read, you come to the punishment that can be inflicted by the court of law. But that punishment is when the person is successful as far as commission of an offense is concerned. What happens when there is an attempt, namely he is unsuccessful, he could not achieve the goal or the object, how you are going to determine the quantum of the punishment is the question for our consideration. And then this can be understood, this I mean for this it is necessary that, well, you read, once I mean you come to know, to find out punishment as far as attempt is concerned, there are some sections in the Indian Penal Code. For example, if you read section 307, which lays down punishment for attempt to commit murder, read section 308, which deals with punishment for attempt to commit culpable homicide not amounting to murder, read section 309, with which we shall be dealing, which deals with attempt to commit suicide, or read section 393, which deals with attempt to commit a robbery. Is also, there is express provision which is made as far as the offence of attempt to commit an offence is concerned, which is also an offence. But there are many more sections. For example, for A wanted to commit theft with respect to money purse of Mr. B, and he has thrust his hand into B's pocket, and he had to take out hand without money purse because B's pocket was empty. What is A's liability? This is exactly the illustration that you read when you come across section 511, namely last section as far as Indian Penal Code is concerned. And that deals with what? Whenever you have crossed the stage, somebody has crossed the stage of preparation, there is attempt on his part and the attempt is unsuccessful, that is an offense, yes, no doubt about it. But for that attempt, there is no express provision which tells the quantum of the punishment that can be inflicted by the court of law. And hence, under such circumstances, in order to know the quantum of the punishment that can be inflicted by the court of law, we always refer to last section of the Indian Penal Code, namely section 511 of the Indian Penal Code, which tells you the quantum of the punishment that can be inflicted by the court of law accordingly. So that is the role of section, or that is the importance as far as last section, namely section 511 is concerned, which deals with attempts, punishment for attempts to commit offences punishable with imprisonment for life or other imprisonment. So with this now, there are some more aspect with which we want to deal as far as the distinction between preparation and attempt is concerned, which will be clear during course of time. As to, in the next lecture, when we take into consideration some more other illustration, so it becomes possible for us to understand. So during the next lecture, but by that time now, this is the time where you can go through the sections dealing with attempt. For just to read the sections. Forget about, we will work out all the details during course of time. But by taking into consideration one or two more illustrations, it will be possible for you to know the distinction between preparation and attempt, because that is must from the point of view of determining the criminal liability. As long as the person is undergoing stage of intention, the question of liability doesn't arise. As long as the person is undergoing stage of preparation, barring few exceptions, the question of liability doesn't arise. His liability starts only when he has crossed the stage of preparation, with which we will continue our discussion as far as our next lecture is concerned.